The object of framing an issue is to determine the material point of disputes between the parties for the purpose of adjudication. Issues can be framed on a question of law or fact, or a mixed question of law and fact. The decision on the issue settles the lease in favor of either of the parties. A distinct issue is to be formed when a material proposition of law or fact is affirmed by one party and denied by another. Also, there is no necessity to frame an issue when the parties are not at dispute on a particular fact or law. At times, despite pleadings, when a specific issue is not framed, but when both the parties to the lease have let in evidence and rendered their arguments on a point, the decision on which is intrinsically connected to the main issue, then the court is bound to render a finding on the point of dispute before deciding the connected issue one way or another. In that case, it becomes the duty of the court to analyze the evidence before it and render a decision on all disputed questions of fact or law, directly or indirectly in issue, so as to put an end to the lease. The Limitation Act, 1963, restricts the right of a litigant by prescribing a time limit within which action must be initiated. Its object is to provide a time or period within which the action has to be initiated. The object of the Act is not to destroy a vested right available in law, but to prevent indefinite litigation and therefore only prescribes a period for initiation of the litigation. This court has described the object of the Limitation Act, 1963 in the following decisions. 1. Bharat Barrel and Drum Manufacturing Co. Limited vs. Employees State Insurance Corporation, AIR 1972 as 1935, Para 7. The object of the statutes of limitations is to compel a person to exercise his rights of action within a reasonable time, as also to discourage and suppress stale, fake, or fraudulent claims. While this is so, there are two aspects of the statutes of limitation. The one concerns the extinguishment of the right if a claim or action is not commenced with a particular time, and the other merely bar the claim without affecting the right, which either remains merely as a moral obligation or can be availed of to furnish the consideration for a fresh enforceable obligation. Where statute prescribing the limitation extinguishes the right, it affects substantive right, while that which purely pertains to the commencement of action without touching the right is said to be procedural. 2. N. Balkrishnan vs. M. Krishnamurthy, 1998, 7 SCC 123 that the Limitation Act is based upon public policy, which is used for fixing a lifespan of a legal remedy for the purpose of general welfare. It has been pointed out that the law of limitation are not only meant to destroy the rights of the parties, but are meant to look to the parties who do not resort to the tactics, but in general to seek remedy. It fixes the lifespan for legal injuries suffered by the aggrieved person, which has been enshrined in the maxim, Interest Republicae ut sit finis litium, which means the law of limitation is for general welfare, and that the period is to be put into litigation, and not meant to destroy the rights of the person or parties who are seeking remedy. The idea with regards to this is that every legal remedy must be alive for a legislatively fixed period of time.